Wow. That's the only word I can describe the first episode. I looked at the feedback we got. Folks, you sent us a lot of great questions. I mean, a lot of great questions. I hope we got all the answers to you, and we're really excited to do this next episode. So this is great. We didn't know what to expect, how this concept would go over, but so far it seems to be going over well. So like we talked about, it's interactive. Keep the questions coming. We're going to get the answers to you, whether it's today or tomorrow. We're going to get you those answers. And also keep in mind about that survey, to be honest with you, when I looked at the survey results, I was looking to see if I had to cut Scott or Cam. Looks like they both made the cut. Guys, so far so good. I can't make any promises for this particular episode, but for now, you made it to the next episode, so well done. And remember, it's very short term. It's what have you done for us lately?
As always.
So then also keep in mind the PowerPoint. We'll make sure we get you guys a PowerPoint after this episode as well. We got a lot of great feedback on those PowerPoints, so we think it's a great resource, so keep with it. So as to this particular episode, before we get into it, Scott, I think you're going to recommend something for us today. What do you got?
Yes, this is the the Philly Favorite IPA by Iron Hill Brewery. It's more of a tropical IPA, not overly hoppy. Iron Hill has a number of locations. I've been to several of them. Food's always great. The beer's great. Not just IPAs like so many of those breweries. They have everything from lagers, some pretty good barrel-aged stouts, things along those lines. So I always enjoy what they have there.
Oh, great. So let's get to the episode. So what we're going to talk about today is the handling of garnishments and levies, the do's and don'ts. So, folks, it's part of your regular business, right? You're getting these levies, you're getting these garnishments, and you got to get them responded to. So what are some of the tricks of the trade? So with that in mind, let's kick it off. Scott, what do you got?
So the question is, what happens, or we get a notice from the court saying you have to hold this account. What's the process? So what typically happens is a creditor or anyone really, a plaintiff in a case gets a judgment for $6,500 as an example. They're trying to collect on it. The defendant has been unwilling to pay. They then seek to enforce the judgment through the courts. They get an order of garnishment, order of levy in PA or Jersey, saying go out to the bank, either a specific bank or generally, depending on where it's filed, and the bank then gets served the order by the sheriff or in New Jersey a court officer saying if you have an account under this person's name, put the funds on hold. At that point, the bank or credit union immediately has to put a hold on any funds in the account that are non-exempt funds, meaning they're not Social Security, they're not subject to a certain protection.
Well, you said immediate, Scott, so let's kind of take that through. Sheriff comes into your bank, comes into your credit union, comes into your institution, it's handing you this hands you this paperwork. By immediate, does that mean, hey, the teller who gets it has got to do something? Is there a timeline? Is there a process? Do we have some time here?
It's dictated by court rule how long you have to respond to the questions that you might get served, but it is almost an immediate hold on the account that anything that's in it is now frozen, subject to if there's outstanding checks that might be in the process of clearing. That's a different topic. But generally speaking, what's ever in the account as of that date would then be restricted from use.
So would you say that's a training thing in reference to the institution so that, because oftentimes, correct me if I'm wrong, some of the sheriffs will literally just hand it to a teller.
Correct.
So there should be some sort of process in place to make sure that gets to the appropriate person in your institution, right?
Yes. A sheriff will just walk in, give it, ideally they hand it to a bank manager or someone that is a level higher than a teller, but typically they just might walk in and hand it and say, I got this, you all deal with it. And then unfortunately, sometimes you have situations where it gets to that person, it sits on their desk, they don't process it fast enough, which could potentially open the bank or the credit union up to penalty through the court for failure to act quickly enough on putting a hold on the account.
Now, is it always a sheriff or constable who will serve that? I mean, what's your been experience on that?
Typically, yes, it would be a sheriff in Pennsylvania, or a constable, depending on which level you're enforcing the courts through or the judgment through. In New Jersey, it would be the sheriff, or in New Jersey, special civil part is a court officer. So special civil is anything less than $20,000 is filed in the special civil part. It used to be 15. They recently upped it to 20. And court officers tend to be a little bit more aggressive in serving banks. You might tell them to serve Bank A, and they'll go out and serve 3 or 4 different banks that you don't ask them to because of the way that they're compensated. But at that point, once they are served the document, the account has to be frozen. So, Mike, what have you seen, or what's the process generally in Pennsylvania as far as notifying the plaintiff what's on hold?
I appreciate that, Scott, because that is one of the most important parts. So now you've held the account. So the account is frozen, no access to the member, to the customer, to that account. So the next thing that needs to take place is you need to determine what type of account it is. And there's a variety of accounts, right? So it might be a joint account, it might be a joint by entireties, it might be a custodial account. So the first thing you need to do is determine what type of account. And generally speaking, if it's an entireties account, entirety, as we all know, is husband and wife, right? In most states, the husband and wife accounts are not attachable, but there's certain states a little bit different. Pennsylvania, you can't attach it, so you wouldn't even freeze it to begin with. So once you've determined the type of account, what you then want to do is look to the funds that are in there. And this is where it can get a little bit tricky. So you've really got to take your time with it. So what you're really looking for is what type of exemptions might apply, because you don't want to have a situation where you've frozen an account and then there's funds in there that should not have been frozen. So Scott is absolutely correct. Your instinctive way, once you're served with that writ, is to immediately put that hold on. But then you've got to begin your review process pretty quickly to determine what's in there. So the first type of exemption out there relates to federal funds. And folks out there, let me tell you something. If you walk away from one thing from this particular series, this particular episode, is take this with you. It's the Bureau of the Fiscal Service, U.S. Department of Treasury. I'm telling you guys, this document should be at every one institution, because what it does, it tells you how you need to handle a federal exemption. Social Security, SSI, railroad benefits. The worst thing you can do is not properly handle those accounts, because those funds are not attachable. And I've had situations where where our institution has attached those funds, and only bad things happen. So what happens? So you receive that notice. Under this guidance, you have a 2-month look back. So you got to look back and say, okay, do I have federal funds in here? And you look back 2 months. And if there are, those funds cannot be frozen. So keep that in mind, folks. Make sure you're very, very cognizant of and careful about the federal benefits. Now you talk about your state exemptions. Each state's going to be a little bit different. And Pennsylvania, for instance, you can't freeze that first $300. There's exemptions related to pensions. We talked about exemptions related to husband and wife, right? All those different types of things. So you want to look to those and be very careful. Now, there's one final area, which is a pretty cool one that you guys need to be aware of. So say, for instance, and I think, Cam, you're going to be talking more about it, is related to security interest, cross-collateralization, set-offs. This kind of ties together. So if you have a security interest in some of the funds in those accounts, your security interest takes precedent over theirs. So say, for instance, Scott, you took out a loan with your local institution. And for that loan, you put up as collateral one of your CDs. So now Cam started to sue you because you know what? There's some issues with you.
It happens.
There's a long line there, I'm
Yes,
thinking.
indeed.
So he sued you and he got a judgment against you. So he goes over to the institution, he files that writ. And he says, I want that CD. Well, you do not need to turn that money over because your security interest supersedes or is greater than that attachment. So that's something you got to keep in mind, because we see that all the time. We have our institutions come to us and say, oh, I turned that over. You didn't have to. You're giving away your collateral, which you didn't have to do. So those things are extremely, extremely important. So be careful about that. And just one final topic before I kind of flip it over to you, Cam. So let's talk about those Social Security benefits one more time. Let's say, for instance, you have an account and there's $500 in there Social Security money. But then you've taken that money and you put $300 into another account. Well, that first account with Social Security, which we just talked about, that is exempt. You can't touch it. Even though you know the $300 got moved into the other account, guess what? That money is attachable. So what you got to be really careful with is your job is not to make those type of calls. Just because you see the money going from one account to the next, it doesn't matter. That is attachable. So again, this is the booklet, guys. Make sure you get your hands on it. We'll make sure it's available at the end of the presentation, but make sure you get it. So with all those different types of exemptions, with the reviews that are necessary, Cam, what's the consequence if the institution does not follow the guidance, if it doesn't do what they're supposed to? What happens?
Well, thank you, Mike. And the consequences can be quite severe. Now, first, I want to point out that you guys have already mentioned putting a hold on funds is some action that needs to take place immediately. The next step for you is, once you complete that review process, is begin preparing your response to the issuing party as soon as you possibly can. So you're going to be receiving a notice to put a hold on an account, and along with that, a request for, well, a list of questions called interrogatories that you'll have to respond to. Those are essentially treated the same as any other pleading that is filed with the court. So that is where you need to make sure your response is timely. And what I recommend doing is reach out to the party that issued you the summons or the notice that you're responding to and ask them for an extension of time if you need it. It is important that you make sure your response is sent to the issuing party in the court within the time frame provided for in that notice.
Now, Cam, I'm going to cut you off there. So do you have to file with the court, or can I just mail to the other counsel? What do I have to do?
You have to do both. You have to file a copy with the court as well as mail a copy to the party that actually served it on you.
Okay.
Now, the reason the timing is so critical in these responses is because if you fail to respond timely, then the party that is seeking that garnishment, they can actually turn around and request the court enter a judgment against you, the institution, for the full amount they're seeking from the the borrower.
Wait a minute.
Yeah.
So let me get this right. So you have that judgment against Scott we've talked about earlier. So, and I'm the institution, I'm the credit union, I'm the bank. I get served with interrogatories. Say you got a $20,000 judgment against Scott. Mm-hmm. You're telling me if for some reason we don't timely respond to those interrogatories, we for some reason just don't get the job done in response, that $20,000 judgment can now be mine?
Correct. And that is money that you, the institution, is losing out on, regardless of the ability your borrower or your account holder has to pay that back. So you can even have an answer to an interrogatory that says, this individual has $0 held with our institution. But if you don't timely file that response, you might be on the hook for the entire balance of that judgment due to your failure to plead. And that's why timing is so critical in these situations.
So there might not even be an account at your institution, and you could be on the hook if you don't do what you're supposed to.
Exactly.
Have you seen that situation?
It can happen, but again, what I always recommend to our clients when this issue arises is reach out to the other side. And I know we handle it the same way when we're representing the creditor who's issuing this request for a garnishment and serving the interrogatories. It's always a lot easier to grant an extension of time and work with the other side than it is to fight about this in court. So that's what I recommend to the institutions that are being served these notices, is reach out to the party that served it on you and ask for that extension of time. 9 times out of 10, they will grant you a reasonable extension, and you do not want to suffer the potential consequences of a failure to respond timely.
And I can tell you just from our own experience, we have a lot of clients, a lot of folks who come to us for that advice, especially as it relates to these exemptions, as it relates to the timing mechanism. So absolutely feel free to reach out to us anytime you receive those interrogatories, and we'll make sure that we can give you the right advice in that regard. I'm sorry to cut you off there, Cam.
Thank you, Mike. There is one other practical issue I wanted to mention as well, which is, do you have to notify the account holder that you've been served a garnishment or an order to hold funds in the account? Now, generally speaking, you're not actually required by law, or there's no statutory requirement that you notify the account holder. Instead, though, it's our advice just practically to notify that account holder It doesn't mean you can do so before you place a hold on the funds. You still have to comply with the order and hold the funds, as you guys have already discussed thoroughly. But from a practical standpoint, this is your customer. Odds are they're borrowing money from you, or at the very least use you for banking services. It is a good idea to notify them after the hold has been put in place, just so they understand what the purpose is, and you can explain to them that this is something you're required to do by law, not a voluntary choice that you, the institution, has. It is another party that is requiring this hold.
And if I may just make one friendly amendment to that, if that account does have some of those federal benefits in it, one more time, here's the booklet. There's a model notice in here. So for those federal benefits, there's a model notice that they have from the U.S. Department of Treasury saying, here's the notice you need to send. So quick friendly amendment. So if there is that federal benefit in there, you want to make sure you're following that model notice. But I completely agree with you. In reference to the rest, you're absolutely on point.
Scott, as it relates to responding to these notices, was there any differences as far as how it's handled in New Jersey?
It's slightly different. It's the same concept, but slightly different in that in New Jersey, there's not a specific. In Pennsylvania, the questions related to garnishments are set effectively. New Jersey, they get notice or they get served the order by the court officer or the sheriff. They then send effectively a form or a letter back to the court officer or the sheriff saying, this is the amount on hold. It differs bank to bank what it looks like, but it's effectively the same thing that says, this is the amount on hold. It doesn't really mention too much about who the account holders are or goes into the detail of a Pennsylvania response. It just says, if you have if your judgment of 20 grand against me is entered, and they find an account with my name, they'll hold 6,500 of it, and they'll just send a form out to the sheriff, and then the sheriff in turn notifies us. We then go to the court to get the order to turn over. It's called an order to turn over, and we attach a copy of that form to that. And the other slight difference in New Jersey is, in Pennsylvania, the exemption is $300. In New Jersey, it's $1,000. And it has to be claimed by the individual. However, in recent months, certain banks have started to, on their own, withhold $1,000. That's without the consumer asking for that to be held, which is a questionable, which we don't recommend doing. They have to come forward, even if there's $50 in the account. They have to apply for the exemption with the court and have the court issue that. All the other same rules regarding holding Social Security benefits, pension funds, et cetera, they still apply. It's just the process of the automatic exemption in New Jersey and Pennsylvania is slightly different.
Well, that's a great point, Scott. So, and I've seen it, and you guys have seen it as well. Oftentimes, our clients, they want to do the right thing for their customer, right? So they know these exemptions are out there, whether it's the $1,000 in Jersey, the $300 in PA, the marital exemptions, different types of things. It's their obligation to just report the news, right? That's how I tell them. Your job is to report the news. You're not there to make the news. Let the customer file the exemptions he's supposed to. Certain things you have to do related to those federal benefits and certain statutory benefits, but you want to be careful. I mean, I had a client one time come to us and say, well, I got this joint account. I know they're married, but I said, is it entireties? Well, no, but I know they're married. It doesn't matter what you know. Now, if you want to be able to talk to your customer and take that extra step, get their marriage certificate and tell them to go talk to the attorney, different stories you want to go over and above. But you don't want to be in that situation that Cam described where you're on the hook for the money. So it looks like we had a few more questions coming in. So, I mean, this would be great to knock out a few questions at this point. Oh, thank you very much. Let's see. Is it possible to extend the time to respond to a garnishment? So, Cam, I think you talked about this a little bit, but could you give us some more information about it?
Sure, we did touch on it briefly. Generally speaking, the best way to approach the issue of extending time to respond to a garnishment notice is to do it informally. And by that, I mean reach out to the party that's issuing the garnishment notice and just simply ask them for an extension of time. Now, if you either can't get a hold of them or they're not agreeing to it, you have the option of filing a motion with the court to try and extend the time. However, that is a process that can become costly, and you don't know how the judge will decide that, and you have to provide a basis for why you need the additional time to file a response. At that point, you should have already placed funds on hold, reviewed the account, and be in a position to respond to the interrogatories. Again, it's unlikely that you're going to have a difficult party to deal with who will not grant you that extension, but if that's the case, you just need to go with an all-hands-on-deck effort to get the responses filed as quickly as possible. But again, as we said before, 9 times out of 10, the issuing party will often grant you that extension.
Okay. Now I'm going to show you a little magic trick again. I want to make a question appear. Watch this. Look at that. Look at that, huh? Out of the air, just made it appear. So what do we got? So what happens if while an account is on hold, another deposit comes into the account? Are those funds now subject to a hold? That's actually a great question. Scott, you were talking about that a little while ago. That is an excellent question.
Yes, so even though the funds that are in the account are on hold as of theoretically the moment the garnishment is served on the bank, any funds that come in after the fact, so if someone gets their next paycheck in, which is a situation that happens from our side of things all the time, of someone calls in, there's an account on hold, and then the paycheck goes in, and that paycheck is on hold, and the person calls in because they're upset that we have garnished not only $500 that was in there, but the $2,400 that gets entered as their paycheck. But anything while that hold is on the account, anything that's not a protected fund that goes into that account is on hold as well and subject to the levy.
So any sort of deposits that come on during that time period, paychecks, any deposit of any sort?
Yes, outside of the protected funds of Social Security or pension benefits, things that you couldn't garnish beforehand are still exempt. But anything that comes in after that, after the hold date, until the point that the court issues the order saying to release the funds, those will be held at that point.
So is it fair to say it's a continuing obligation, that it just continues until that response or the court gets involved and says it's over?
Yeah, until the court gives the order saying this is what you have to turn over to the plaintiff, to the party seeking the money. At that point, that's until you get that, anything that comes in is on hold. But once you get that, until if there's another writ served, at that point, it would go on hold again, but in that gap in between, there's no obligation to keep anything on hold that's in the account.
Okay, and do you see that causing a lot of issues with the institutions? I mean, from a logical standpoint, you think it's just a hold in a point in time, right? Let me just look at my account at that particular point in time for my customer.
Correct.
And it's that extra element where you got to keep that eye on it throughout, right?
Yes, because similar to what Cam was talking about earlier, if the creditor seeking to collect finds out that there were funds that should have been held that weren't held, you are open to them seeking an order from the court saying, against you as the bank or the institution, saying you need to give this money. This is their money. You could have a judgment or an order saying, the bank, you messed up. You should have held that extra $2,400 that came into the account.
Okay, that makes sense. Well, what do you say, guys? Do one more question? Okay, we'll grab one more. Oh, thank you very much.
No magic trick.
I know you didn't want to go to the well too often. So what do we got here? What do I do if an account is opened as a joint, but not marital, but I know the members are married? Kind of the topic we talked about earlier, right? It's that example that I presented about the bank manager knew they were married. And he contacted me, called me up, and we had a relationship in the past dealing with this bank. He said, Mike, I know they're married, but it's a joint account. I said, well, that's not for you to decide. You're not in that position. He said, well, I know they are. Funny story, he said they're friends of his, and they went out together socially often, so he knew for a fact they were married. He said, it doesn't matter. If you want to provide me the marriage certificate, then I can, as the attorney on their side, say, you know what, I will say you have my authority to release this account. But unless that attorney on the other side says he is giving you the authority or the consent to do it, never, and I mean never, should you ever release that account. So just something to keep in mind, that you can work with the attorneys on the other side. I mean, you've seen that from your guys' experience, right?
Yeah, typically, yes. We're, at least from our perspective, we're always willing to at least discuss the file further.
Just never assume, right? If you're the bank, if you're the credit union, just never assume. So that's a good place to end. So once again, would like to thank you guys for attending episode 2. Again, please fill out the survey. Take that PowerPoint with you. We think there's a lot of great information. Some of the information we might not have even shared here is part of that. And also, please, you're going to see our names and our information here. If you have any questions, reach out to Cam, reach out to Scott, reach out to myself. We're here to answer any questions you may have. And finally, so February 15th, put it on the agenda for you guys. February 15th, what do we got coming up? We've got, let me tell you, we've got cross-collateralization, set-offs, and the impact of bankruptcy. So again, fill out those surveys. Maybe I don't make the cut. Maybe one of these guys don't make the cut. We'll see. Thank you very much.